In this video, I'll show you June 1st, 2020, Plano, Texas resident Greg Kime was pulled over by K-9 Deputy Chilfie of the Burnett County Sheriff's Office on Highway 71, just outside of Austin, TX. Mr. Kime was driving a rental car with California license plates. After Mr. Kime pulled over, Deputy Chilfie exited his police vehicle and approached the passenger window of Mr. Kime's rental car.
Hey, how you doing? I'm Deputy Chilfie, the Sheriff's Office. Are you okay?
Yeah.
Because you're
60 below road.
Well, you're driving 60 in a 70 zone and you keep braking. It's consistent.
I wanna keep the distance, safe distance from the car. If the car in front of me is...
There was no car in front of you when you were doing that at the time.
There was I'm keeping the distance.
At one time, there was a car in front of you, but most of the time you're driving behind.
I was following the line of the cars.
Okay.
And I always like to keep the safe distance.
I'm just making sure you're okay, because someone doesn't go 60 miles per hour typically in a 70 zone and brake all the time.
I saw you behind me.
Okay.
And I know that you're driving with that speed. I thought maybe there is some sort of road repair or something like that, so everybody is driving pretty much the same speed.
Okay.
And that's why I was following the normal pace.
Well, you're just going to get a warning. Do you have your driver's license and insurance on you?
Yeah.
Okay, can I see that, please?
Deputy Chilfie informs Mr. Kime that he will be given a warning for his driving behavior, but does not specify what traffic offense Mr. Kime allegedly committed. Section 545.363 of the Texas Transportation Code states that an operator may not drive so slowly as to impede the normal and reasonable movement of traffic, except when reduced speed is necessary for safe operation or in compliance with the law. The statute also permits certain governmental authorities to declare a minimum speed limit on the highway when they determine from the results of an engineering and traffic investigation that slow speeds on a part of a highway consistently impede the normal and reasonable movement of traffic. If appropriate signs are erected, giving notice of a minimum speed, an operator may not drive a vehicle more slowly than that limit, except as necessary for safe operation or in compliance with the law. The U.S. Supreme Court concluded in the 1981 case of United States v. Cortez that, quote, in determining what cause is sufficient to authorize police to stop a person, the totality of the circumstances, the whole picture must be taken into account based upon that whole picture. Detaining officers must have a particularized and objective basis for suspecting the particular person stopped of criminal activity. Applying this totality of the circumstances approach, the 7th District Court of Appeals of Texas determined in the 2000 case of Richardson v. State that the evidence did not show that an officer had a reasonable suspicion that a driver going 10 to 20 miles an hour under the speed limit was an impediment to the normal and reasonable movement of traffic when only one vehicle passed the driver and there were no other vehicles behind the driver waiting to pass him. When Deputy Chilfie pulled Mr. Kime over, there did not appear to be a posted minimum speed limit or any impediment to traffic created by Mr. Kime's driving. Therefore, it is likely that a court would find that Deputy Chilfie's stop of Mr. Kime was not justified by a reasonable suspicion that Mr. Kime was violating Section 545.363 of the Texas Transportation Code.
Where are you headed to today?
Spicewood.
Spicewood?
Actually, Briarcliff.
Briarcliff?
I had a car broken, like my car, the Honda Odyssey. I left it at the car repair shop.
Okay.
And because of that, I broke my car.
Where do you live?
Normally?
Well, I mean,
my
your address.
Plano.
And where? Plano, Texas?
Yeah.
What brings you this way?
As I said, we were on vacation here. I'm with my wife, and my car broke on the road, so I left it at the car repair shop in Marble Falls.
Okay.
Colonial car repair shop.
Well, so what brings you to this part of Texas besides that your car broke down?
As I said, we were vacationing for a couple of days.
Yeah, I understand that, but where?
Briarcliff.
Okay. All right.
My cousin lives in Briarcliff.
Okay, that's what I was trying to get to. So this is a rental car?
Yeah,
Do you have the rental agreement?
it's in the email.
It's in the email. Did you rent the vehicle
Yeah,
under your name?
yeah.
Okay.
Deputy Chelfie asked Mr. Keim about the vehicle's rental agreement, which is a legal contract between a car rental company and a renter. In the 2015 case of Rodriguez versus United States, the Supreme Court determined that when a police stop justified only by a police-observed traffic violation exceeds the time needed to handle the matter for which the stop was made, it becomes an unlawful seizure. However, the court identified several ordinary inquiries incident to a traffic stop, such as checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance that can lawfully be conducted during a traffic stop without straying from the stop's mission. While there is not extensive case law on the subject of rental agreements, the courts that have considered the issue have generally determined that officers have the authority to inspect a rental agreement as part of a routine traffic stop. For example, in the 2019 case of United States versus Leslie, the United States District Court in the Northern District of Oklahoma determined that inspecting the rental agreement for a vehicle is similar to the common inquiries. In the Rodriguez decision, as the intent of the officer is to determine whether the driver is authorized to drive the vehicle. Similarly, the Third District Court of Appeals of Ohio concluded in the 2011 case of State versus Hollins that, quote, an officer, while conducting a stop for a traffic violation, may, as part of his or her investigation, review a rental agreement if one exists. In addition to conducting background checks of the driver's license, vehicle registration, and license plate. Based on the reasoning in these decisions, a court would likely find Deputy Chelfie's inquiries about Mr. Keim's rental agreement to be reasonable.
Do you have, yes.
Is it 60 miles safer than 70?
Safer than 70? You're supposed to go to the speed limit most of the time.
It's a maximum. The speed limit is the maximum 70.
Okay.
So if I'm going 60, it's below the maximum, and also
If that's what
I was following the cars in front of me, and I was trying to get the safe distance.
your driving behavior was consistent with someone that may be intoxicated, which is why I stopped you.
Deputy Chelfie informs Mr. Keim that his driving behavior was consistent with the driving behavior of an intoxicated individual, which is why he was stopped. As we discussed earlier in this episode, a police officer must have a reasonable suspicion that a driver has violated the law for a traffic stop to be legal. In the 2014 case of Navarrete versus California, the Supreme Court held that, quote, reasonable suspicion depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act under that common sense approach. We can appropriately recognize certain driving behaviors as sound indicia of drunk driving. The Navarrete decision also identified weaving all over the roadway, crossing over the center line on a highway, driving all over the road, and driving in the median as examples of the types of erratic driving behaviors that are strongly correlated with drunk driving. In 2010, the National Highway Traffic Safety Administration researchers interviewed police officers from across the United States to develop a list of more than 100 driving behaviors that have been found to predict impaired driving. The list was reduced to 24 cues during 3 field studies involving hundreds of officers and more than 12,000 enforcement stops. Driving at a, quote, UN, quote, slow speed of 10 miles per hour under the speed limit is included as one of the signs of intoxicated driving, along with other speed and braking problems such as accelerating or decelerating for no apparent reason, problems maintaining proper lane position, swerving or drifting, vigilance problems such as slow responses to traffic signals or officer signals, and stopping for no apparent reason, and judgment problems like following too closely or unsafe lane changes. However, even though driving at a slow speed may be an indicator of drunk driving, it is typically not on its own sufficient to establish reasonable suspicion of drunk driving. In the Richardson case we discussed earlier in this episode, the 7th District Court of Appeals of Texas held that because the trooper admitted there might be other reasons why a person would be driving slowly, and he cited no other reason why his suspicions were aroused, driving 20 miles per hour under the speed limit in and of itself would not justify an investigatory stop for driving while intoxicated. Therefore, it seems likely that a court would conclude that Deputy Chaffee's stop of Mr. Keem was not justified by a reasonable suspicion that Mr. Keem was impaired.
Okay, most Texans don't go 60, they go 80.
But I originally kind of like to keep a little bit extra safe distance behind the car because
You have that back.
people would stop erratically, without
Okay.
any...
All right. Like I said, you're just going to get a warning. What I'm going to have you do is hop into my passenger seat while I type that out. Was that?
Warning?
A warning, yeah.
What?
For your driving behavior.
My driving behavior was absolutely perfect.
Okay, if that's what you believe, that's fine. You're just getting a warning. I'm not giving you a ticket.
I know, but I don't understand. What was the...
I have to document my stops, okay? And I'm giving you a warning. I was making sure you're not intoxicated.
You want to do the breathalyzer?
No, I don't believe you're intoxicated this time, which is why I'm getting you a warning to get you out of here. I have to document...
But, does it go on the record?
No.
Okay.
All right, so I'm going to have you hop into my passenger seat of the vehicle while I type out your warning so I can get it to you, okay?
Deputy Chaffee ordered Mr. Keim to sit in the passenger seat of the police vehicle while he typed out the warning. During the process, Deputy Chaffee asked various questions about Mr. Keim's background, residency, employment, and physical attributes. Once the warning was issued, Deputy Chaffee told Mr. Keim that he was free to leave. Mr. Keim uploaded this video to his personal YouTube channel along with the dashcam video of the incident, but it is unclear whether he filed a complaint or will be pursuing legal action. Overall, Deputy Chaffee gets AC- because although much of the deputy's conduct was debatably legal, he exercised poor discretion, displayed a misunderstanding of reasonable suspicion, and ultimately issued Mr. Keim a warning for driving too safely. In the video, you can clearly hear Deputy Chaffee say that he is required to document every stop, and he insinuates that the warning he is issuing will serve as that documentation. However, there are no legal requirements for officers to document every encounter with a citizen, and he's likely referring to a departmental policy. Many departments have policies that require their officers to file incident reports whenever they make contact with citizens, but these reports are generally for administrative purposes and do not serve any significant legal function. Although a warning will not reflect on Mr. Keim's driving record, it could be used against him in court if he were ever issued a citation for a different traffic violation, and the deputy's implication that a written warning was warranted for administrative purposes is inaccurate. The deputy's decision to issue a warning was likely an attempt to meet the department's quota for traffic stops, and contrary to the contention of most departments, departmental quotas are a very real and well-documented matter of public concern. Several states have outlawed the practice of issuing officer quotas, but even in those states it remains a prevalent issue. For example, police quotas have been outlawed in California since 2009, but as recently as 2013, the city of Los Angeles paid out a $6 million settlement to a group of police officers who accused their superiors of imposing a secret traffic ticket quota system. The concept of ticket quotas does nothing more than erode public trust and generate unethical revenue streams for the municipality. And while many states are actively working to combat the issue, it will be extremely difficult to eradicate the use of quotas without significant oversight. I have little doubt that Mr. Keem was a victim of quota enforcement, and all departments who participate in such conduct are betraying the spirit of the American justice system by carrying out a practice that essentially amounts to roadside extortion. Mr. Keem gets an A, because although he could have exercised his right to silence, he remained calm and compliant throughout the encounter, challenged the legitimacy of the deputy's conduct, and made a concerted effort to dispel the deputy's suspicions. It is clear that Mr. Keem was driving in a manner that was focused on road safety, and the fact that he was issued a warning for being a safe driver is ridiculous. Deputy Chiuffi stated in the video that drivers typically drive at a high rate of speed on Texas roadways, so it would make sense for Mr. Keem to take extra precautions on a highway that's known for. As drivers. If the deputy's allegation of rampant speeding is accurate, then it seems counterintuitive for him to waste time issuing warnings to citizens who are driving safely, and instead, perhaps he should focus his attention on the drivers who are actually presenting a legitimate threat to others. Mr. Keem handled himself well during this encounter, and I commend him for keeping his emotions in check. But I would also encourage him to gain a deeper understanding of the right to silence and the citizen complaint process. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out the ATA Patreon page for more police interaction content. Thank you very much for watching the video. Subscribe our channel for next video.